welcome to Trial Stories. Today we have a special guest. We have trial attorney Richard R. Mogg from our firm, the F&A Injury Lawyers, and we're going to talk about a case that we just settled days ago, and it was an interesting case, a premises liability trip and fall. Hi, Rick. How are you doing? How's everything going?
How you doing, Arcady? Thanks for giving me this opportunity. It was great working with you on this case.
Oh, thank you. Yeah, thank you. It was an excellent result. So let's dive in. Tell us about the case. What was this case about?
Okay, we have a nice lady who was walking on the sidewalk in New York City's Chinatown, in the area of Hester Street. And as she walked on the sidewalk in front of the defendant's store, she was caused to trip and fall on a crack in the sidewalk. And as a result, she sustained really bad injuries. Both hips sustained fractures. She wound up going to the hospital by ambulance, and within 2 days, she had surgery on both hips where they had to put hardware into the hips on either side. She was a really young lady, vibrant in terms of the way she was living, older in terms of age, but really enjoying her life. And this accident really changed her life for the worse forever.
Oh, wow. Yeah, that's horrible when you hear that. And then that's great that you got to know her, that you spent time with her, you got to see like the human story, how it affected her. That's always powerful. So,
well, you know, our office, as you've professed to all of us, and we all work together like this, is this action was actually in its early stages. There was only one piece of testimony that we had from a client called a 50H, but we were able to work with that in this case. But it was because of meeting with her and talking to her and learning about her background. I really think that helped us in this case.
Wow, that's really cool. Yeah, so yeah, that's a good point, because a lot of people who watch our channel, like on YouTube or the podcast, what they usually ask is like, how long is my case going to take? So this case, you were able to settle it even before any depositions. The depositions are when the defense attorney questions the plaintiff, the person suing, and asks them, how did the incident happen? What are your injuries? And there's a court reporter who transcribes everything, right? Types everything down. So even before depositions, all you had was that preliminary hearing, the 50H, and you were able to settle it. So that's great.
Well, the ability to settle the case that early, as you know, I'm a trial guy. That's what I've done my whole career, and that's what I do for this office. And when I usually get a case and I'm successful, I'm in court already. We've gone through, like you said, depositions, testimony of all the parties. We've had to exchange all the medical records, and it's quite a process. Here in New York, it can take up to 3 to 4 years. We had this case only, I think, about a year and a half going into the second year, and we brought it to mediation.
That's pretty quick. That's a good result. That's a good result. And like, how much was the settlement for? Let's tell everybody.
Well, I think, with all due respect, I think the audience would like to know where they started. And they started with a number of $75,000 was their first offer. And
wow, $75,000. That's low for what you described. So you're talking about she fractured both hips, right? And she had, I believe, rods and screws and the open reduction internal fixation. I remember seeing the package, and it said one of the rods was like a 12-inch rod that they had to put in.
That's exactly right, Arcady. And I'll tell you the truth. What happens here at our firm is the way we dig into the medicals is key. To know the medicals here, we were able to fight back against the defendants. They were arguing that she had a condition called syncope, which is when you get dizziness. And they said she had it for years. As a matter of fact, they produced records that showed she had it, but they couldn't show that on the date of this incident, suddenly and coincidentally, she had a dizzy spell and fell right where this crack was. Another thing that they tried to argue in the medicals, which you and I prepared for, I remember sitting down with you and going through it, was this condition, biphosphonate articulated fracture, which is because of brittle bone, you were caused to fall. Both arguments, as we were able to do, we were able to argue it away. But that's by really going into the medicine and knowing your medicine.
Oh, I see. I see. So they were saying that because she has the syncope. Well, that's one of the common things defense lawyers do is they say, hey, it wasn't the hole or the raised sidewalk, the defect, but it was anything else. It was the fact that maybe years ago you had a dizzy spell and maybe the syncope just came into play at that exact moment. That's what they always try to do. But the second point that you mentioned is very interesting about the brittle bone. So essentially, they're saying that she's just the type of person that's likely to have this, right? If she has a little fall, then she's going to have these horrific injuries because she has brittle bone. But what did you do to counter that? Tell us about how you countered that.
Well, what I did to counter it is, and as you know, because you and I discussed the medicine before we went in there, I found out that she never had any problems in terms of what they call symptoms. So she was asymptomatic. So where she may or may not have had this condition, she never had medical treatment for it. She never had a prior accident where she hurt herself. As a matter of fact, she had just retired from being an active restaurant worker. She was active. Now she was in the golden years. Here she is, 66, 67 years old. And suddenly this crack, which we had photographs of, and it was a defect on that sidewalk, this just changed her life. Within about 2 to 5 seconds, her whole life changed.
Right. Yeah, that's a good point. And also there's that, I mean, the fact that she's more susceptible to injury, but they take their plaintiff as they find them, right? Like you could have two people. One could be like a bodybuilder. So he gets hit by a car, no injury. But if you take an 80-year-old like octogenarian and maybe he's got like a eggshell, skull, he gets hit by that same car, that same impact. He gets, traumatic brain injury and a coma for, months and months. So one case might be worth nothing. The other case might be worth tens of millions of dollars. That's just the way the law works, right? Yeah.
Well, the way we prepare our cases, Katie, like you and I always discuss, prepare it as if you're going to trial. All that we're required to do is prove to a jury that the negligence of the defendant was a substantial factor in causing these injuries. You take the plaintiff as you find them, and then the question becomes, listen, Mr. and Mrs. Defendant or owners of the building, but for this accident, our client would not have sustained these injuries. You wouldn't have these questions. She didn't wake up that morning and say, oh, I'm going to go to the store, and as I find the crack, I'm going to conveniently fall and break both hips. And
No, that's a great point. That's a great point. And I noticed also, like in the mediation package, you had mentioned the pattern jury instruction, the PJI, and I believe it was the one about sidewalks and the fact that to prove negligence, you just have to show that the sidewalks were not reasonably safe. And I think you like you mentioned, you had an expert too, a possible talk of an expert, like a safety expert that went out there and measurements of how the hole or the raised condition and photos, like you mentioned. So that's really good.
I think one of the items that this firm is known for is early on, before we actually say we think we have a case, like you and I have discussed, we'll put an expert on it. So the expert can go out and say, listen, this crack is a defect. It's a non-delegable duty, which means the city of New York says, owner of that abutting sidewalk, you can't say it's someone else's responsibility. It's your responsibility. Your responsibility to fix that crack. And we have the medicals because the doctor causally related the injuries to this accident. And that's key for this case.
Yeah, that's really important. That's great. So because a lot of firms, they probably wouldn't hire an expert because there's an expense, right? You hire an expert to go out there like an engineer. You have to spend maybe $2,000-$3,000 and time. And they might just say, you know what, I have the defect, I have the injury, why don't I just go and try to settle it? But they're not going to get the types of numbers that we got on this case, and they're not going to take it all the way to trial.
Another hidden issue in this case, and a lot of people ask this all the time, they're outside, they're walking in the city or walking in Queens or one of the boroughs or anywhere, and people say after they fell, was anybody around you? No. Oh, no one witnessed your accident. Well, in this case, this was considered to be a blind accident as well, because the defendants were claiming the only thing that was seen was a bystander happened to be telling the ambulance people, oh, I saw her go from a standing position to falling. They said that wasn't a witness to the accident. Common sense, what we argued was, hey, who is not standing before they fall? Unless, I said before, unless you're crawling up the sidewalk.
Right, of course. Yeah, that's
And
a
the
good point.
negotiations were based on that. That's why they started at $75,000.
Oh yeah, so tell me about the negotiations. Like, how did you get them up? Like, what tactics did you use? What were their? I mean, we know some of we discussed some of their arguments already, but what were some of our arguments during the mediation to get them to start moving from 75 to the next level until it was finally settled?
Okay, so as you know, Katie, we're here and we're reaching out to people in the community who are looking for justice because they're injured. And I believe our firm is one of the top firms here in New York that can handle stuff like that. But I don't want to give away all our secrets, but I will tell you this. When you're negotiating with defendants, you've got to look for the top dollar amount and start there. And if you go any lower than that top dollar amount, many times amounts that the defense will go, oh, we're not going to even talk to you about it at that high amount. Well, you got to start there. And that's how I did it, because I believe these grave injuries, and the only way to really compensate this lady would be to get her a fair and reasonable and just amount.
Yeah, that's a great point. So what did you start out at? What was your first, demand, or what did you ask for in terms of a settlement, the reasonable amount?
I asked for 2.5 million.
Wow, that's a high amount. That's great. That's great. That's good to start out there and to be confident in the amount that you think it's worth, like, the amount that you're going to put on the case.
Kind of going with the theory that you kind of brought to my attention, because over the years I've tried so many cases for us. I would often come back to you, and I remember you tell me a high amount, and I'd go, I don't know if I feel comfortable asking for that amount. And then I remember many times you coming back to me and saying, well, Rick, how much is the value of like your brother's arm or your sister's leg? When you think of it that way, then when you ask for these amounts, that's almost not enough. So
right.
That in this mediation.
Yeah, that's a great point, because when you're in trial, you can't, it's like a golden rule violation, right? You can't say, imagine this happened to you, to the jury, because that's so prejudicial, and they'll be, you can't do that. But in terms of like preparing the case, you could think of it that way. You could think of, okay, if I have a brother, what if this happened to my brother? What would I want? Or if this happened to me or to my family member, what would I want? What would be justice? And then you start thinking about the case, and then you do some Zoom calls with the client or go visit the client at their house, break bread with them, you get to know them. Then they become your brother, then you want to, or your sister in this case, and you want to come and you want to really fight for them. It just empowers you. So it's great stuff.
Well, that's something that I hold dear to my heart and to the heart of our law firm, that we are trial lawyers. Without giving it up again, so to speak, there's artful ways for us to bring those amounts to the jury without actually putting the mirror in front of them. Think of your mother, think of your father. There are other ways to do it, but you got to feel comfortable inside with asking for those amounts of justice, or else the jury will feel if you're not comfortable.
Right, of course. That's a great point. And then, so tell me about, so let's just continue with the negotiation. So you're at 2.5 million, they're at 75,000, and how did you guys bridge the gap? Like, what happened next?
I believe it or not, I actually have some notes here. They're like on post notes as I was going through it. And it was like going back and forth, because you see, we were dealing with two defendants. One was the gift shop who leased it from the owner, and the other one was from the owner. So they're both like saying the other one's responsible. And again, if you remember, we sat down in your office and we actually looked at the lease, and we found out the responsibility was really on both of them. So
right.
Pinning them back and forth. And before you know it, we went from 75, and then I came down to 2.3. Then they itched up to 200, and it kept going back and forth until we came to an area where, as you and I were discussing, we thought it was coming now to an area where justice can be served. because there were problems on the case. You always have to look at it that way. A jury can always come back and say, you know what, I just don't see this, and maybe they come back with a low number. You don't want to roll the dice with your client's money when you get justice in your hand.
Right, that's true. Especially this was New York County, right, which is Manhattan, which is a more conservative, affluent county where jurors tend to be awarding less money or sometimes even giving out defense verdicts. So that's good. So what was the next level that they jumped to? That they jumped to after the 75?
Well, at some point, and this happens in mediations, the mediator is talking to us separately. And at one point, the mediator came into me when we were in the 250, 300 range, and he said, I don't think there's any more room. I don't want to move anymore. At some point, you've got to consider your client. And as you and I have done in so many mediations and trials, Arkady, you got to take a stand. So I remember you and I had a low amount, and our low amount was anything lower than 550. We were not going to settle this case because we thought we could work the case up to a better number. And I just kept that in my head, Arkady. And as you know, you were on with me on and off. Both of us kept going through it until we felt comfortable. And the client was telling us she was real comfortable with the number we wound up with.
Oh, that's great. So they're at 250, which is like $250,000, 300,000. So at that point, what was the next step? Like, how did we get them to get more, and more? Was it based on a little bit of a lowering of the demand from 2.3 or something else, or some kind of meaningful argument about the case, or what was the next?
As I was saying before, I would come down a little. They kept going up. So eventually I went into the $1 million marks and went down to 1.7. They came up to 3.25 because they were going in smaller increments. And I was just trying to get near to the number that we discussed. And then at some point, actually, for about an hour and a half, it kind of broke down and they didn't want to budge. And they do this thing with you sometimes. And I remember I called you and you said, let them do it. They were like, oh, we're going to have to call people on the next level. That's kind of to make you quit. And as you know, Arkady, we've been doing these a long time. You never quit and I never quit when it comes to these mediations. So I just stood my ground.
All right, that's how insurance companies work. Yeah, they have levels. Like, there's one adjuster up to like 250, another adjuster up to 500, another adjuster. So they had to go and get approvals, authorizations. Yeah, that's pretty standard. So then,
yeah.
Oh no, go ahead. I was just going to ask you. So then, tell me what happened next. Like, let's tell the final part of the story.
Okay, so finally, I came down to 800,000, and this is after we're going into the third hour now, and they called, quote unquote, the next level, and their whole point is they think, again, we have a lot of contributory negligence. In other words, blame the plaintiff. You caused your own accident. Your medical condition caused your accident. You were dizzy. No one really saw you actually trip and fall. All these arguments. And then as I came down to the 8, I was taken into a private room and the mediator said, would you consider something in the upper 500s? I said to myself, you know what, if I tell them that, that's what we're going to get in the 500s. So I said, no, I've got to be closer to 7. Within the next 2 conversations came down to 650. They came up and we finally, after you and I talked and we called the client, we decided 625,000. Early stages of the case and everything we've discussed, we thought that was a good result and the client was very happy.
No, that's great. That's great. So like going from 75,000 to 625,000 all in the same day, just in a matter of hours. That just shows you how because a lot of people think that, the insurance companies are like independent, or the insurance companies are their friend, or they could even handle cases, without an attorney. You just get into a car crash, you call up the adjuster, and they're going to give you a fair offer. And this just shows you, like I had a case once where they offered me 15,000 and they said, this is a great offer. You'll never get more. There are witnesses against you. And I ended up settling that case for like $750,000, even though it was in federal court with a truck. And then the witness actually blamed the truck driver 100%. He didn't blame my client. So it was the exact opposite. So that just goes to show that the fact that they're moving so much goes to show that you need an advocate, and these insurance companies are not your friend. You know, they're a business, they're a for-profit business, and that's great that you're able to do that. $625,000. That's an excellent result for this type of injury in an older lady. She was in her early 70s, right? Yeah, sure.
By the time we took this to mediation, yes, and frankly, what we did, you and I, and I'm actually holding it in my hand.
Oh, wow.
This mediation package that we put together, this took us, what, 2 to 3 weeks, plus exhibits. We had medical exhibits. We had exhibits from the deposition. We had surgery illustrations. So to put this package together, I think our effort and us being tough, quite frankly, I think that's what got our result.
Yeah, no, that's great. That's an excellent result. Yeah, I noticed that too, because I was looking at the packages, and their package was like 2 pages, you know, the defendants, and then our package was, 15 pages of analysis of the case law, of the experts, of the medical records, like you said, the illustrations, and then we had all the exhibits too, right? Like the actual medical records, the expert report, I saw the photos, the hardware, and the medical record, and it was like 80 pages altogether. So it really, a very good effort, a lot of work, but that's what gets rewarded. When you're willing to work hard, you get rewarded.
That's the whole point. And I think if I were to walk away to say anything to people who want a personal injury law firm who fights for you, the fight comes in the type of work we put into the case.
Yeah, no, absolutely. Absolutely. Okay, so thank you. Thank you for joining me. And yeah, absolutely. I think that was a great result, $625,000 before depositions, because if the case goes, first of all, you don't know when you would get a trial date, right? You'd have to do depositions, which could take a year, file your note of issue, might have to wait another year or more because of the pandemic, all the backlog. And then you're talking like 2025, and then you don't know what's going to happen, right? What if the jury gives less, or what if the jury, like we said, it's a conservative venue? So to get that kind of number early, that's just amazing. I think that's a miraculous result, really good result.
That's a great last point you just made, in that if someone is injured and they come to our office, it doesn't necessarily mean you're going to have to wait and wait and wait, because we'll go on the attack right away. We assigned and retained an expert. We already started putting value on the case. I think the moment the plaintiff came into our office, we started getting to work on it. I got to tell you, that's why I enjoy trying cases for our office.
No, that's awesome. That's awesome. Thank you so much. So that's a great result. And yeah, hopefully we'll have a few more. We have one in July, right? A trial, also a premises case, July of this year, 2022. We have a few others coming up. I may do a small one on my own in late March of this year. So we'll see. We can do more of these videos and more trial stories. And so we look forward to it. Absolutely. Thank you so much for coming on and telling everybody about this case.
Thank you for this opportunity, Arkady. I very much appreciate it.
Okay. Have a great day. Okay. Bye-bye.